Hi, welcome back to Senate Judiciary. We're continuing our session from this morning, but it is technically a new meeting, so we will do a roll call. Pierre?
Yep. Senator Kriegel,
Here.
Senator Crum,
Present.
Senator Hicks,
Excused.
Senator Kolb,
Excused.
Chairman Olson.
Here.
You have a quorum.
All right, and just a housekeeping matter for House Bill 43, we left the vote open. And so Senator Hicks changed his vote from excused to aye. And on House Bill 43, Senator Crum changed his vote from excused to aye. So let the record reflect. Okay. We're back on House Bill 103. We only have until 2:15, so a little shorter period of time, and we do have two other bills to get through. So we're going to finish up public comment. I believe we are down to just one commentator. Mr. Rendenza is online. All right. Welcome, Mr. Rendenza. We can see you, but maybe we can't hear you. Can you hear us, Mr. Rendenza?
It's working on our end because captions are working.
Yeah. Yeah, I'm not sure, Mr. Rendenza. Everything's working on our end.
Hey, Mr. Chairman,
Yes.
just a suggestion. Maybe someone who has a cell phone could text him and tell him to log out and log back in.
Oh, okay.
Well, now.
Mr. Rendenza, can you hear us?
I hear you now.
All right. And we hear you.
Great.
All right. So on House Bill 103, there were questions that were asked and were punted to you. We're hoping that you can kick us off by answering some of those questions.
Sure. I made some good notes here. And I know that I got a little bit of credit for writing the draft of this, but I think the credit properly goes to Senators Kriegel and Kolb, because as you recall, last year, they had a significant number of questions and concerns. So we essentially sat down and tried to channel their concerns into this new bill. So, I'm just a scribe. The minds that this came out of are sitting to either side of you. Now, I know that there was a question about that is a new one, which is about balance. And I can see how you could make the mistake looking at this, saying that this is unbalanced. But if you'll recall, that woman who testified last, whose son passed away, who got sued for speaking up, right there, the balance is tilted. All right, so this bill seeks to restore that balance. In that case, the process was the punishment. The process is the imbalance. What this does is it creates a method by which she can now get on equal footing. Now, I can see how there is one thing that I'm sorry, I don't recall which of the gentlemen raised it, but when you do look at the non-moving party in this, it does say that if it's frivolous, made in bad faith, or brought solely for the purpose of delay or harassment, the court may award fees. I would suggest changing that may to shall, because that is a reasonable change here that I think fixes it. Now, there was also a question, why shouldn't the fees just go in two directions? Well, then again, what you've done is you've simply taken what was balancing this for a woman like that and putting it into an even worse situation. I can give you a solid example of that. I'm defending a case in Florida, and the Florida anti-SLAPP law has this old provision in it. It actually originated in its HOA law for some reason, but it said that the prevailing party on the motion gets fees. So I'm representing a girl who was kidnapped and sex trafficked, and she reported that to the authorities. And to retaliate, her rapist sued her for defamation for what she said in the police report. Now, I don't think any of us have any doubt in our mind that that statement shouldn't be the subject of a defamation suit, but it is. And so she had to make a choice of, well, what happens if the judge simply denies it for no good reason, which I hate to say, as a 20+ year litigator, that happens all the time. Let's say the judge just says denied, which happens a lot. Now she's facing fees. Even if she was going to win the case at the end, she could wind up winning that case and owing more in fees than she would have if she had just lost the case or defaulted. So you need to look at this not as is the actual anti-SLAPP process balanced, but what balance does it restore to the playing field in the first place? Now, again, you brought up a good point, and frankly, I'm embarrassed that that says may. I think that was my drafting, and so I would like to be corrected on that. So on page 8, line 19, I would change that word may to shall. There was another really good point that came up, and I was texting with a number of people about this, where the gentleman brought up there's a somewhat retroactivity of this on page 15. I was under the impression that in the draft that I wrote up, that was removed. I think that is a very good criticism of the bill, and that should be amended out. Page 15, lines 12 and 13. Although I do see the good-hearted nature of it, that it should perhaps apply to people who make a rush to the courthouse in advance of this bill. I don't like the way that changes the landscape of retroactivity. So the next thing I want to address is the 60-day period that was talked about that's in some anti-SLAPP laws. We have that in the one in Nevada, and I'd like to correct the gentleman who brought up that Nevada has two-way fees. I wrote that law. It does not. It only has it in this frivolous or vexatious. Essentially, this language is almost identical to Nevada, where if it's frivolous or made in bad faith or brought solely for the purpose of delay. Now, Nevada, California, and the Uniform Act, they all have this 60-day period. But I think the 60-day period is a bad idea, and in practical terms, it does not actually exist. And I know that sounds funny because you can read it right there. And you say, well, how does it not exist? Well, in anti-SLAPP laws that I've litigated under, and that's been in a number of states, when there is this time period, often you're in federal court. In federal court, I apologize, Mr. Chairman. I am, the references I'm giving you are to the introduced version, not the engrossed version that you have in front of you. So I'm terribly sorry for that. But I think you can still find what I'm referring to. So when we talk about the 60-day period, that is a purely procedural element. So in federal court, that doesn't apply. And also, if a Wyomingite is sued outside the state of Wyoming, but is able under Restatement 145 to have the choice of law provision required Wyoming law, that procedural provision would not come to them. So that would only apply in state court in Wyoming. But SLAP plaintiffs do like to do this little trick these days where they'll add a somewhat bogus federal Lanham Act claim to most of their claims. And then, boom, now you're in federal court. The 60 days doesn't apply anyway. Additionally, as I believe Mr. Crossman testified, it is in the lawyer's best interest, it is in the party's best interest to dispense with this early. I did hear the gentleman's concern about, well, what if some unscrupulous lawyer knows they're going to win this case from the beginning, so they just let the line reel out and reel out and reel out. Well, that would actually, if that were going to happen, that would have happened in federal court at some point under the Nevada law, under the New York law, under the California law, under any of the UPEPA states laws, and it just hasn't happened. Also, it's quite a risk to take because what you want to do is you want to get rid of this as early as possible. There's no guarantee, for example, the plaintiff is even going to be able to pay all of those fees. So it would be quite a gamble to take. And it hasn't happened, and it wouldn't make sense for it to happen. Also, if the defense lawyer was able to see from day one, this case is doomed at some point prior to after the close of trial, you would imagine the plaintiff's lawyer would figure that out as well. And if they cut and run before an anti-SLAP motion is filed, well, then there is no liability. So they do have the opportunity to cut and run at any time they like. So I don't think that that's really something, it's a good thing to bring up, but I just don't see it as something that's worthy of being concerned about when you really look at it. I have seen these cases, though, where if you look at the way this is written, last year's created a special process, which was a problem that the gentleman had. This year, what we have here is something that simply rides on top of existing pre-trial procedures. You bring this with a motion to dismiss, or with a motion for summary judgment, or with a motion for judgment on the pleadings. It's not a whole new thing. This is what simplified it. Now, the only reason I have seen where you would go past the motion to dismiss, for example, I had a case recently in the District of Nevada in federal court where the plaintiff seemed to us pretty clearly to be a public figure. They had appeared in Playboy, Maxim. This is a gentleman who had a big business empire. He had appeared in about 40 different magazines, yet claimed and dug right in, I'm not a public figure. Well, you can't introduce that on a motion to dismiss. So you had to have discovery where the defendant had to establish all of that in the record. Once that was established in the record, well, then he moved to dismiss. He moved for summary judgment, I'm sorry, and then brought along the Nevada anti-SLAP law to shift fees. Another thing that we removed, and I noticed that there's been some discussion of this Uniform Act that's floating around. And I've looked at the Uniform Act, and I think the Uniform Act is simply not a good bill. It was written essentially at a time, it seems to be a throwback to a time before federal courts were considering the Erie Doctrine in these cases. So it is almost entirely procedural instead of substantive. And then one thing that was of concern last year was the imbalance of the fact that if you invoked last year's law, you could stop discovery immediately, and then you had to move to open discovery. We've gotten rid of that. Now, that might seem in some ways to be, well, that's a big weakness in this. But, well, yeah, we've taken a little bit of a weakness and infused it into this and made that discretionary on the part of the court. That's how it works in federal court. In federal court, the stay on discovery does not apply to the Nevada or California statutes. And so what you do is you ask the court under Rule 1 of the Federal Rules of Civil Procedure, to stay discovery at that point, and then the judge will sometimes do it and sometimes not. It all depends on what the particular needs of the case are. We leave that as the province of the judge's discretion now. So I guess what else is, there was another question. I believe, I think, Mr. Chairman, you raised this, and if I'm wrong, excuse me, but it really isn't that unusual to have a fee shifting statute. In federal court, you have it in the Lanham Act, the Copyright Act. I mean, just so many different Section 1030s, 15 USC Section 1030. They're all over the place. In Wyoming, I just found real quick the Wyoming Royalty Payment Act, the Wyoming Consumer Protection Act, Child Support Enforcement, and the Wyoming Public Records Act. So it is certainly within the public policy of this state. The one I'd really point to would be the Public Records Act, where you have an imbalance, right? You have a regular citizen up against the might of the state. And if the state just says, we're not going to give our records to you, well, that citizen needs a way to be able to have a level playing field. So that's why this legislature put in a fee shifting provision in that act. The other thing that was a concern here was the fact that if somebody drops the case after a motion invoking this act comes before them, can they cut and run and just stick the defendant with the bag? That comes from the Texas statute and from the uniform statute. So the uniform statute seems to be getting a lot of positive attention here, but the provisions in here that we brought in from it seem to be something that troubles the committee. But I understand there is an amendment, and I like this amendment, that while it may not moot the immunity, so you can drop it and you still get to have a determination on the merits if you're the defendant, you can't get your fees from the plaintiff unless you gave them 7 days notice. And I like that amendment because if somebody does have a truly frivolous or awful lawsuit, you can say, look, I'm not going to just spring this on you. You've got 7 days to think about this. You think about what you want to do. Now, they might still dig in and say they want to stay put. Okay. But if you haven't given him those 7 days pre-suit notice, pre-filing notice, you don't get your fees. So if you want to do it as a surprise attack, go right ahead. All you're going to do is end the case early. Which brings me to my last point. There was a concern raised by the trial lawyers lobbyists that I just don't know if they read the bill. The claim was that it limits evidence. Well, it doesn't do that. What the bill does is it simply articulates the standard for summary judgment. So it doesn't say that the court can't continue, it's not some new standard. It's really just outlining what you do in every other summary judgment or motion to dismiss proceeding. So this isn't new. This isn't cooked out of whole cloth. This is what you already have in every single case winding through the courts in Wyoming. And then I'd like to point out one other thing that is really actually plaintiff friendly in this bill, but that nobody seems to have picked up on, but I want to make sure you're aware of it when you're thinking about these balancing issues, is that the immunity conferred is available to you pretty much under the same standards you would be under if you were a private figure. In fact, it's identical if you were a private figure suing for defamation and thus only had to prove defamation by a preponderance of the evidence and show that the speaker was negligent. Now, if you're a public figure, I'm sure you're all familiar with the New York Times versus Sullivan standard, which says that there has to be knowing falsity or a reckless disregard for the truth. Now, that's not a bad standard, and we've lived by that for, since 1964. However, some of Sullivan's progeny, even I, as a First Amendment advocate, have a little bit of a problem with them. St. Amant versus Thompson is one of the cases that relies on Sullivan, and it says that even if you fail to investigate or turn a blind eye to contrary information, you still can take advantage of Sullivan. Well, in this bill, you might win your defamation case at the end of the day if you're winning under that St. Amant standard, but you don't get the immunity under St. Amant, because I think that if somebody, for example, any one of you could be a plaintiff in one of these cases, and I don't think it's really fair that a reporter could look at you and say, well, I got one source that provided one bit of negative information about you. I'm going to run with that, and I'm not even going to bother to investigate or look further than that. So I think that this bill, like I said, this is largely Senators Crago and Kolb. I tried to channel all of your concerns from last year, removing every bit of procedure out of this, just making this substantive. And I think that this will make this the most streamlined, but also the most powerful anti-SLAPP law and the most fair one in America. So if you have any further questions, I'm all ears.
Committee, anything from Mr. Rendenza? Oh, all right. Well, I appreciate you zooming in.
Sure, it's my pleasure.
And I believe that concludes public testimony. So I'll go ahead and close public testimony. All right, committee, what is your pleasure on House Bill 103? Any discussion?
Mr. Chairman.
Yes.
I'd like to move the bill before we have any discussion.
Well, I was waiting for a motion, but wasn't getting one, so I thought maybe people just wanted to discuss that.
It's the discussion.
Okay, it's been moved by Senator Hicks. Is there a second on this bill? Okay. I don't think we have a second, Senator Hicks, but we can still discuss it. Any discussion? Senator Kolb?
Yeah, thank you, Mr. Chairman. I think there's a clear need for a bill of this type. The devil's in the details, though. It's got to be worked on a little bit more. I think there's too many holes in it. It's not that I disagree with the bringers of the bill's intent. I think it's noble, but the actual mechanism and how it happens is the issue. It's a very nuanced bill. I think, and I will never support an imbalanced bill. A balanced bill that would allow one side to have more rights than the other side in an action. I mean, I think that's bad policy. And that's what I see within this bill draft is frankly that. It's not that it's not trying to solve a problem, it is, but the solution is frankly could be worse than the problem it's trying to solve. It's unfortunate, but this is what we have. So that's why I was not going to move the bill.
Senator Crum?
Yeah, thank you, Mr. Chairman. I really appreciate the idea behind the bill. I really, truly do. I don't need to repeat what Senator Kolb said, but I would recommend that maybe this is a bill that needs to be looked at in the interim or, in the interim and see if we, a committee could come up with a solution here to do what this bill's trying to do, but fill in a lot of the holes that are here and hopefully address the questions of the committee that didn't seem to be addressed this last time that the committee had, in a prior year before that weren't addressed this time. Thank you, Mr. Chairman.
Senator Crago?
Thank you, Mr. Chairman. So despite the insinuation that we had something to do with drafting this bill, we did not, nor were we consulted about that. Just want to make that perfectly clear. We may have had this conversation last year. I would say in certain places the bill is better. In certain places we doubled down and went the opposite direction. So I want to make that perfectly clear. I actually, and I told the sponsor a few minutes ago, I think this is something we need to deal with. It is an important topic. I will be fully supportive of us taking this up in the interim and creating a committee bill where we get to work it through the interim because it's a big deal. And I think we can do it right. I think we have a good jumping off point with this bill. But there's a lot of holes in it that we got to fill and fix. I'm happy to help do that as we move forward. Again, I think it's an important topic, but this bill is not going to get us where we need to go. So thank you, Mr. Chairman.
Senator Hicks.
Yeah, Mr. Chairman, I've always been prescribed to the philosophy that we don't kill the good in pursuit of the perfect. But I would also concur that in my time, sometimes to get as close to the perfect as possible, it takes years of work on study on these issues. And I think if we're serious and we're going to take this up as an interim and try to aspire for the perfect, then I'm more than comfortable with that direction. If that's not our intent, then certainly I think we ought to move the good in front of the perfect. But if we can work this and bring it back and work with all those people, I think that makes for a better project. And sometimes good legislation takes years to get in place. And so.
Thank you, Senator Hicks. Yeah, just echoing what's been said, but I'll also say that I'm a lot further along with this bill than I was a year ago. I definitely see the need for this type of legislation in Wyoming. But as I talk to various stakeholders, if you will, that are involved in our court system, there's pretty much unanimous consent that this bill was not the vehicle to do it. But there is also pretty much unanimous consent to move it forward into an interim discussion. So I know we thought about that last year. It didn't become an interim topic, but I do think there's a lot of support for this to be an interim topic this year. And no offense to Mr. Rendenza, but I'd rather Wyoming write our own laws than an attorney from Nevada write our laws. So I think that the interim Joint Judiciary Committee is the best vehicle to get this right. So those are my thoughts. All right. Thank you, Representative Ottman. We don't need a motion to recommend it for interim. Interim topics have already been submitted. So this topic I will bring this topic as chairman to the committee. Okay. Next bill for our consideration is House Bill 157, Protection of Parental Rights, Causes of Actions. Representative McCann. Welcome to Judiciary.
Thank you, Mr. Chairman, committee. House Bill 157. I'm assuming you just want me to go ahead and dig in.
Yeah, go ahead. Whatever you feel is necessary for us to know about the bill, and then walk us through the bill itself.
Protection of parental rights, cause of action. House Bill 157 is a narrow accountability bill. It does not create any new parental rights. It simply creates a limited exception so that existing parental rights in Wyoming Statute 14-2-206 can actually be enforced when a state agency or subdivision infringes upon them. This bill is intentionally limited. This bill allows only declaratory or injunctive relief plus reasonable attorney fees and costs for a prevailing parent. This framework also mirrors what Congress is considering at the federal level with H.R. 6860, which creates a private right of action for parents under FERPA and PPRA, and similarly limits relief to declaratory and injunctive relief and reasonable attorney fees and costs. I'm happy to walk through the bill. Page one creates a new section within the Wyoming Governmental Claims Act. It provides that a government entity is liable for damages resulting from a violation of parental rights already in statute under Wyoming's statute 14-2-206. Importantly, this ties liability directly and only to the existing parental rights statute. It does not create new parental rights. It does not create a generalized parental cause of action outside that statute. The notice of claim timeline can expire before a court ever reviews the issue. And this That's one of the main things that slows all these things down for the parents. This ensures alleged violations are reviewed on merits rather than dismissed on procedural technicalities. What it does not do, it does not eliminate procedural standards in court. Parents must still prove a violation. Page 3, amendment to Wyoming Statute 1-39-118, limitation on awards. This bill creates an exception so that attorney fees and costs may be awarded to a prevailing parent under 14-2-206, paragraph D. Clarification, attorney's fees are available only if the parent prevails. This ensures access to court for families of ordinary means. It discourages frivolous claims because the parent must win to recover fees. Page 4, civil cause of action establishes that if the state agency or political subdivisions infringes parental rights under this section, the parent has grounds for a civil cause of action for declaratory or injunctive relief. The action is not subject to the Governmental Claims Act notice requirement. A prevailing parent is entitled to reasonable attorney fees and costs. Relationship, Wyoming Statute 14-2-206 already allows infringement on parental rights only when the government demonstrates a compelling state interest using the least restrictive means. This bill does not author those standards. Courts will continue to uphold lawful children protection actions. What does all this mean? This bill does not protect abuse. It does not interfere with neglect investigations. It does not weaken criminal enforcement. It simply allows judicial review when the statutory standards are allegedly not met. Congress is considering a similar enforcement framework in HR 6860. That bill creates a private right of action under FERPA, FERPA, and PPRA. It similarly allows declaratory and injunctive relief and prevailing party attorney's fees. HB 157 mirrors that limited enforcement structure at the state level. Both bills focus on enforceability of existing rights, not expansion or substantive rights. In closing, HB 157 provides a narrow injunctive remedy for violations of existing parental rights without expanding damages, liability, or interfering with child protection law. I stand for questions.
Questions, committee? Senator Cole.
Yeah, thank you, Mr. Chairman. Good afternoon, Representative McCann. Could you give me a couple examples of this infringement that we're talking about here? A few of them that would be applicable to this bill, like how are you trying to solve that, or what's the reason for the bill? And then to be clear, there's one other follow-up question or statement I have. To be clear that the court shall award reasonable attorney's fees on the back, not, it's a shall, not an option. But could you give me something that I can follow for a couple of examples of why this is necessary?
Well, you heard one,
Representative McCann.
I'm sorry. Thank you, Mr. Chairman. Senator Cole, you heard one earlier today that was from our area, that young lady with her son. There's been several of those. I sat down with approximately 3.5, 4 hours with 4 women that their kids were being bullied in school. There's probably at least 12 more. But because of the payback, if you will, they haven't really come forward. So there's still some gaslighting, if you will, on the family and the children. The form of bullying in this case, in all 4 of these cases, where these kids were dry humped in front of other kids. That's sexual assault. They have taken, they've tried to go to the police, I've only heard the parent side of the story. I did try to contact the school board via letter. They did not send anything back and basically filed an ethics complaint against me. Said it was out of my jurisdiction. So that was the main cause that got me involved is the embarrassment to these children. The police said it was a district problem. The district in their investigation came back and said that, well, there was still clothes on, no penetration, so it's not sexual assault. I find that a little bit difficult to believe. So that's the reason I got involved with this.
Senator Craig, oh, sorry, Senator Cole, did you have a follow-up?
Yeah, just a brief one. Just to be clear, going back on the bill title, this is creating an exception to governmental immunity. So if there, I guess my question is if you had other issues that were involved with some, exploitation or whatever it may be with an individual, I guess that really isn't about governmental immunity at that point. It's a question of, say, an assault. And so I guess really focusing on the governmental immunity part of it and what you're trying to, I guess, hold accountable.
Representative McCann.
Thank you, Mr. Chairman. We do have legal counsel. I'm going to defer that one to legal counsel on Zoom.
Representative McCann, struggling a little bit with the language on page 3, line 23. If a state or its political subdivision, that's fine, infringes upon the parental rights. So I'm trying to understand how a court would draw the line between the agency, as an example, doing its job versus infringing. What would be your what would be your standard of what is meant by infringes?
Well, the parental rights are already in statute. So anything among those I would consider infringement. Those are already established. We're not here to change those or add to them. Again, I would refer anything beyond that to the legal representative.
Senator Craigo, go ahead.
Thank you, Mr. Chairman. Top of page 3, Representative.
Mhm.
So you're creating a carve out under the notice provision for the governmental claims procedure. So right now, if you're going to sue a governmental entity, even if we've waived governmental immunity, which we have in lots of cases, you still have to provide notice to that governmental entity and allow them to, essentially the purpose is allow them to submit it to insurance and possibly pay the claim without going through all the processes of litigation. Now, technically, I think you can file your notice and your lawsuit on the same day. I don't think there's a waiting period. So I guess my question is why do you want to create a carve out where you at least don't have to provide notice to what, in this particular circumstance, the school district, and at least have them the opportunity to come to the bargaining table, negotiating table and say, yeah, there's probably something here. We should turn that over to insurance without going straight to the courthouse and maybe costing everybody more money. Any idea on why you want to do that?
Representative McCann.
The legal aspects of it, I'll leave it to the legal person, but these parents have been through the gambit. I mean, there's like 7 or 8 hoops that they have to jump through. And then there's time constraints on it and all this. And their experiences is they just keep getting put off until they can get a procedural claim that says, well, we can throw this out because they didn't meet the technicalities. So that's, the reasoning behind that, at least from my understandings. But, the legal part of it, I'll leave it up to the legal.
Representative McCann, who I don't know who you're referring to. Who's the legal person?
We have a Matt Sharp on Zoom.
And is this Matt Sharp's bill or Representative McCann's bill?
It's my bill, but he helped.
But you just want to punt every question?
No, sir.
Okay. All right. Senator Craigo, follow up?
Yeah, I just wanted to make sure that the representative knew this will be literally, I mean, there's, as we talked about earlier, there are lots of carve outs under the the Governmental Claims Act. This will be the only one, the only type of claim that does not at least have to submit notice to the governmental body, which means they could get sued and maybe not even know for months that they've been sued. They won't know till they've been served.
Mhm.
And so we're not even providing them notice or the opportunity to right or wrong if they think they've done something wrong. We're not even giving them that opportunity. We're just gonna have the sheriff show up and say, yep, you did, you're being it's alleged you've done something wrong and you don't have the right to negotiate that. This will be the only type of lawsuit that does that. Literally the only one.
Representative McCann?
I'm not aware of any other ones. I can't say one way or the other, that this would be the only carve out. I'm not familiar with any of those that would be over that.
Senator Hicks?
Yeah, Mr. Chairman, Representative McMahon, when you went through this process, and I understand the circumstances you're talking about, did you contemplate any other remedies, appeals process? Who would appeal to, how that would look at before we go straight to litigation? Because it's been my experience many times, if there's a provision that provides an appeal process to the circumstances you're talking about, could be to the state school board in a case like this or some other entity, these are resolved quicker and without spending a lot of money on litigation and tying up the court system. But was that part of the consideration? That's what other types of administrative relief that could be affected instead of going straight to a lawsuit?
Representative McCann?
Mr. Chairman, they were considered and they've also been done. Several of these parents have been through the full process. They've jumped through every hoop that the school board and the school district has asked them to jump through, and they just haven't gotten anywhere. They really haven't.
Go ahead, please.
Yes, I understand that. And that's why, was there any other consideration to an administrative relief when that fails? What you've described is exactly the point that I'm trying to get to. If that failed, did you explore any other potential administrative relief that could be implemented without having to go through the court system?
Representative McCann?
Mr. Chair, the parents that I've spoken to have, again, gone through every hoop that they've been asked to do. I mean, the lawyers have been involved. So I don't, other than going to the next step of, as far as this, bringing this bill, I don't know what else they could have done.
Committee? Any other questions for Representative McCann? All right, thank you.
Thank you.
Any agencies wishing to testify on this bill? Welcome.
Good afternoon, Mr. Chairman, members of the committee. Nish Goikolea, Chief Policy Officer for the Wyoming Department of Education. I'm here on behalf of Superintendent Degenfelder, who is in support of this bill. Superintendent Degenfelder has been an outspoken advocate for parental rights and believes that this bill is important to ensure that parents have a clear avenue for redress when their rights are infringed upon. And I'll stand for any questions.
Senator Crago?
Thank you, Mr. Chairman. So does the superintendent have any oversight over any of the schools? Can she get involved at the local level on some of these issues and exert her ability to influence policy there?
Mr. Chairman, Senator Crago. So we receive numerous complaints through our agency, and we have very limited jurisdiction. So typically, as an agency, we try to route complaints to appropriate entities. We also try to communicate between the two bodies and bridge communication where we can, but that's pretty much the limit of what the jurisdiction the department has.
Senator Hicks?
So follow up, and I don't question that, but there's another entity out there called the state school boards. And is there an administrative provision that they could look at these things? Because versus the superintendent's a little different finite responsibility.
Mr. Chairman, Senator Hicks, I do know, as the previous speaker said, that there's been numerous parents that said they've gone through all of the channels and still not come to any resolution. And so I think that's where this bill comes from.
All right, thank you.
Any other questions for the Department of Education? All right, thank you. Any other agencies wishing to testify on this bill? All right, any associations? Welcome, Mr. Farmer.
Thank you, Mr. Chairman. Brian Farmer, Wyoming School Boards Association. Mr. Chairman, there are three pieces of this bill that I have concerns with, and the committee has rightly pointed to each of those. So I just want to go back through and spend just a moment on them. First, at the bottom of page 2, top of page 3, is the waiver of notice that was referenced by Senator Crago. And you can see right there, that's that first subsection. And it's except for this one, this only one. There are no other governmental claims that there is a waiver of notice. So it would be very, very odd for us to assert that somehow something about this would be different from other governmental claims. Mr. Chairman, it is also referenced at the very end of the bill, but we would suggest elimination of that provision. The second thing that we have concern about is at the bottom of page 3, and that is that statement of infringe. So right now, the current law does hold districts liable for actual tangible harm to children. Those are all clear objective standards that we can figure out. But when it comes to infringement, there is no definition. What is an infringement? If I'm a parent and I don't like, if you'll recall, our parental rights law that we passed just recently here had a thing in it about if you're going to have a survey done at the school, you have to have advance notice to parents. So can a parent sue if they feel that notice wasn't properly given? Is that an infringement of parental right? This infringement is a new beast and leads to a lot of lack of clarity and uncertainty as to how it should be applied and understood. The last comes at the end of the bill at page 4, line 6 through the end. And it says a district court shall award reasonable attorney fees and costs to the prevailing parent. Mr. Chairman, I would suggest that maybe should be a district court may award reasonable attorney's fees and costs to a prevailing party, putting both parties on an equal footing, but the may at a very least. So, Mr. Chairman, I do think that waiver of notice is a concern. As you see on that page 4 at lines 4 through 5, it again mentions that waiver of notice. So it's both higher in the bill and right there as well. But Mr. Chairman, I think overall, the process in the Governmental Claims Act is to encourage dispute resolution. It encourages parties to come together to talk about it, to resolve it. And if that is possible, then they can do that. This bypasses that resolution and jumps straight for the litigation. And so, Mr. Chairman, I do have concerns with the bill overall, but a minimum would suggest striking the provisions on the waiver of notice, and then the amendment at the end of the bill. And I would love to have a greater understanding of what that infringement is at the bottom of page 3. With that, Mr. Chairman, I'd be open to questions.
Questions for Mr. Farmer? All right, thank you.
Thank you.
Any other associations wishing to testify on this bill? Any general public comment? Okay, and just so you know, we still have another bill that we need to get to, so we have just a couple of minutes. So just try to be as concise as possible, but tell us what you need us to hear. Go ahead.
Thank you, Mr. Chairman, members of the committee. My name is Patricia McCoy, and I'm speaking on behalf of the chapters Moms for Liberty throughout the state of Wyoming. We're parents. We're not attorneys. We're not policy experts. We're parents who have spent the past several years talking to other families who have throughout this state and what they've experienced. And with that, we support House Bill 157. We've heard from parents who are simply trying to understand. They want to do what's best for their own children, and they're being met with walls. They meet with teachers, they speak to principals, they go to the district office, they attend school board meetings, they send emails, they try to follow what they are told is the process that they have to follow. But too often they're met with resistance. They're told they don't understand the system. They're told this issue is more complicated than they could realize, and they're told to be patient. Some parents tell us they're just trying to get through the year, hoping that the next teacher, the next administrator, or the next school will be different. And yet the system is still the same every year. When they're forced to elevate concerns to the state level, the process becomes even more difficult for them to navigate. The Department of Education can suggest changes. The state board sets rules. The Professional Teaching Standards Board governs licensures, and associations and outside organizations provide guidance that influences districts. But meanwhile, parents often feel like the only people at the table without a voice to be heard. House Bill 157 does not replace local conversations. It does not interfere with lawful child protection actions. It does not make litigation the starting point. It ensures that if a parent's statutory rights are infringed, that there is a clear and enforceable path to accountability. Wyoming law already recognizes parental rights as fundamental, and this bill ensures that recognition carries real responsibility for government actors. Parents are not asking for special treatment. They are asking that when boundaries are crossed, there is a meaningful way to address it, and we respectfully request that you support House Bill 157. Thank you.
Questions for Ms. McCoy? All right, thank you.
Thank you.
Ma'am?
Dear Chairman and committee members, my name is Laura Pavey and I live in Sweetwater County. I'm here today as a parent. I'm not an attorney, but as somebody who's watched other parents struggle to be heard in situations that they should have never reached this point. Over the past several years in Sweetwater County, I've seen a number of very public and painful examples where parents felt shut out by the decisions involving their own children. Parents raised concerns about special education, safety concerns, communication breakdowns, and only to be told that the process is too complicated, that we don't understand it, or that there's nothing more that can be done. In one well-publicized incident, the state investigation found multiple problems related to student confidentiality and parent involvement in special education cases in our local district. Many families still feel that there is no clear accountability or meaningful response in those findings. Other Sweetwater County families have been involved in federal litigation over attempts to be fully informed about their child's education and well-being. Those cases have also shown how difficult and costly it can be for a parent to pursue their rights through the current avenues, even when they genuinely believe their rights have been compromised. There have been expressed concerns that this bill might be a financial burden on the school district or flood the courtrooms with lawsuits. But I think that concerns raised is an important question. If districts fear that, or if there's a fear that districts would face large numbers of successful parental rights claims, what does that assume? It assumes that districts are regularly infringing on fundamental rights. I don't believe that anyone in this room wants to say that school districts across Wyoming are violating parental rights. And if that is truly happening at the level that would destabilize our district budgets, then we have a very serious conversation to have together. This bill does not presume widespread violation. It provides accountability if violations occur. If districts are lawful and respecting parental rights, then this bill should not create a financial disruption. HB 157 is not the first course of action. It does not bypass the everyday school does in good faith. What it does do is create accountability that parents genuinely have exhausted every other option. where their rights have been infringed. Some say that the existing enforcement avenues are adequate. Right now, parents believe that their rights have been violated, must navigate complex federal courtrooms under 42 USC SS 1983, or work within their local district from the complaint process. Our experience shows that local processes often leave parents feeling unheard. Federal litigation is expensive, complex, and equally inaccessible for most families. I know you shake your head and I know you roll your eyes. And I know that you guys think that this is a real problem. This is a real problem, and I'm pleading with you today to hear us. We've tried to pass a parental rights bill in the past. It is hard for parents to find an attorney. We had one mom that the attorney said before they would even take on the case, they wanted $5,000. Now, the school district has unlimited funds. Rock Springs has spent over almost $2 million in litigation fees alone since we started tracking them, or in legal fees. Is that like they can throw money at a parent until the parent gives up, filing appeal after appeal, or discrediting the parent at every avenue. I'm pleading with you today to please at least consider this bill. And with that, I'll take any questions.
Committee, any questions? All right, thank you.
Thank you.
Ms. Rubino.
Thank you, Mr. Chairman, members of the committee. My name is Jessie Rubino. I'm with the State Freedom Caucus Network. I was born and raised here in Cheyenne. I'm a product of public schools here, and I am a licensed teacher and a licensed member of the bar. So hopefully I can answer a few of the legal questions if any remain. During the earlier comments, I jotted down, I think, 6 questions that I think I can handle really easily and dispose of really quickly for you all, because I know you have a lot left on your agenda. So I'll just start right out. Title 14's application of strict scrutiny to parental rights suggests that parental rights in Wyoming are a fundamental right. So I want to just preface all of my comments with that. The right of parents in Wyoming to direct and I'll read it verbatim, to direct the care, custody, and control of their child is a fundamental right. And so therefore it should be treated a little bit differently than other rights and other things that we're going to discuss. The first concern that has been raised is the shall award attorney's fees provision at the end of the bill. A mandatory award of attorney's fees can be found in a couple other places in Wyoming law. So it's not a new concept to have mandatory awards of reasonable attorney's fees and costs. The Public Records Act in 164203F contains a mandatory award of attorney's fees and costs. When a landowner challenges an eminent domain valuation and they win, they're also entitled to mandatory award of attorney's fees and costs, subject to the reasonableness standard, which the court gets to determine. The second concern that I heard, why is this necessary? Aside from the other stories that you've heard today and the story that you heard during the discussion of House Bill 103, another high-profile case out of Sweetwater County that took place 1 or 2 years ago, it's hard to remember now, parents were forced into federal court to sue over an allegation that their parental rights were violated 2 years ago. Thank you, Senator Kolb. And in this instance, federal courts are more expensive. It's often more complicated for people, and it raises the costs for both parties. It raises costs for the parents and it raises costs for the districts, which again is kind of the parents because we're talking about taxpayer funded entities here. Allowing a state private right of action allows Wyoming courts to hear cases involving what Wyoming has already declared to be a fundamental right, which is the right to direct the care and upbringing of your children. It's a state sovereignty issue, and I think that our state courts are much better positioned to assess infringements than a federal court. Number 3 rolls right into what I just said, the word infringement being vague. I guess I would just push back on that. Courts interpret alleged infringement of constitutional rights on a regular basis. It's a normal legal term, and I think Wyoming courts are certainly capable of ferreting out disagreements over things from actual infringements that would rise to the level of a meritorious case in this instance. The fifth concern that I heard, there might be other procedures that are adequate. In some cases, that's certainly true. And I think that not every parent is going to want to go through the headache that is filing a lawsuit. But when it's a serious violation of a fundamental right, this should be an option for Wyoming parents. Again, as you heard during testimony on House Bill 103,
sometimes parents are retaliated against for approaching the school board and going through the administrative procedures that are in place. That's just a fact. The sixth thing, it was mentioned, what about trying to, resolve these disputes before they rise to the level of a lawsuit? I would say that the fee shifting provision, which again is not novel to Wyoming law, the fee shifting provision actually encourages lawsuits from being drawn out and dragged out. So with that, I think that addresses all of the concerns that were raised. Again, we're dealing with a fundamental right that's subject to strict scrutiny, so it should be treated differently. Oh, the notice requirement, that's the other thing. I skipped the notice requirement. So it was noted that this would be potentially the only area of the law where we exempt the notice requirement for claims under the Governmental Claims Act. That's true. This is probably the only time that you're dealing with a fundamental right under the Governmental Claims Act. And so it should be treated differently. Parents have a God-given fundamental right to raise their kids. So with that, I can stand for questions.
Mr. Chairman.
Senator Hicks.
Mr. Chairman, Mrs. Rubino, or Miss Rubino, excuse me. Could you opine a little bit on the issue of exhausting all administrative remedies before this? Because this looks to me like it actually encourages to go to litigation versus exhausting all of those administrative remedies that may be out there. And so would you like to opine on that?
Ms. Rubino.
Thank you, Mr. Chairman. Senator Hicks. The way that the parental rights statutes are written in Title 14, they're not subject to an administrative hearing at all. And in other circumstances, let's say we're talking about a professional license or something like that. Sure, there are exhaustion requirements, but as our parental rights sit in Title 14, there's no current requirement for any administrative procedure to take place anyway. This just provides direct access to courts should they be needed.
So,
Senator Hicks.
Mr. Chairman, just to follow up there, but we're not necessarily talking about parental rights from a standpoint of the fundamental right. We're talking about a procedure that occurred with certain school districts in the state of Wyoming. That does set up a procedure that may be able to go through an exhaustive remedies before we get there. And so I'm not saying that the rights being challenged. I'm saying the process of who's violating those potential fundamental rights there may be a remedy out there other than just going to court. Does that make sense is what I'm trying to convey?
Ms. Rubino.
Mr. Chairman, Senator Hicks, yes, that does make sense. And in circumstances where there would be an administrative route, let's say a parent is trying to access records or something and that they're required to go through the school board, this doesn't change any of that. This doesn't change any existing requirement for anybody to go through the Wyoming Administrative Procedures Act if it would apply to a certain case. What this does is it allows parents direct access to the courts to enforce a fundamental right when it is infringed.
Other questions for Ms. Rubino? All right, thank you. Oh, we got one.
Sorry, I was
Senator Craig.
leaping over here. Mr. Bino, thank you for being here. So just a question, and I'm just sitting here thinking about this. On the Governmental Claims Act, on the very last page, right, we're only allowing the parent shall have grounds for a civil cause of action against the state agency or political subdivision for declaratory injunctive relief, no damages. Am I right about that?
Mr. Chairman, Senator Crago, that's correct. The only financial recovery that a parent could have is their attorney's fees and costs.
And so follow up, Mr. Chairman.
Mhm.
So, Mr. Rubino, the question I have, I guess, is why are we even going in to change the Governmental Claims Act? Is that even necessary if all we're talking about is attorney's fees? I don't know if those fall under the Governmental Claims Act per se. And so my question is, do we have to do all this other stuff, or can we just do literally the last paragraph of the bill and accomplish the same purpose without messing with the Governmental Claims Act? Because I think we're going to have a lot of pushback on the Senate floor messing with the Governmental Claims Act. So question on that. I think that, I have a problem with the notice provision too. We'd get rid of that. You know, it's a whole different scope of practice outside the Governmental Claims Act because we're literally not seeking damages. So any thoughts on that?
Mr. Rubino.
Mr. Chairman, Senator Crago, thank you for that question. the carve out from the Governmental Claims Act is intended to provide parents direct access to the court. And that's the entire intention behind that portion of the bill. It wouldn't destroy the bill if the body truly felt like this is completely unworkable. The point of the bill is to allow parents to access courts to enforce their rights. And part of the reason that the bill doesn't allow for actual damages is because parents aren't out to make money off of these situations. Parents are not out to make a quick buck. Parents are trying to enforce their rights. And that's why the declaratory and injunctive relief is an important aspect of the bill. Parents just want their rights vindicated. And if it's going to cost a lot of money, which it does, to go to court and deal with this stuff, then the government drives a bus through your wall, they should have to fix it. This is the same thing.
Senator Craigo.
Thank you, Mr. Chairman. And I guess I'm gonna follow up on a question I'd asked to the department or to the superintendent's office. I mean, do you think there's a way we could actually do some rulemaking? I mean, we could give legislative authority to do that, to deal with this particular issue. So we're not involving the courts in every single one of these circumstances. We just set out a procedure that doesn't cost anybody anything, and we don't have to get lawyers involved. And we just set out, I mean, we do this other places, a lot of our other, and I know the school boards probably wouldn't like that, but it might be something that would keep us out of the courtroom, but at the same time vindicate those rights that we keep talking about today without I mean, as much as the chairman and I love lawyers being involved in everything, it's not necessarily good for the people of Wyoming. So any thoughts on that? I mean, is that something we could look at as well? Maybe not today, but something going forward.
Ms. Rubino.
Mr. Chairman, Senator Craigo, from my perspective, Wyomingites are entitled to right to the courts, right? Our courts are open to the people. And so they're open to the people for a reason. And when we're dealing with fundamental rights, I think people deserve a day in court. Administrative procedures often do not afford the same level of due process as does a civil courtroom. And so I would just say that this is the right track. Muddying up the Administrative Procedure Act, I don't think is the right way to go when we're dealing with parental rights.
Senator Crum.
Yeah, thank you, Ms. Rubino. I really appreciate the information you're giving. And I'm sympathetic, having kind of dealt with some of those issues personally myself. So I'm sympathetic where you're at, but I'm want to know why we wouldn't want to have a step, at least a choice, where they could have some conversation before we go to court. Why wouldn't there be an option to go to mediation, to have an administrative hearing, to do those type of things in this bill, where there was an option to do those type of things versus just going to court?
Ms. Rubino.
Mr. Chairman, Senator Crum, nothing in this bill prevents that from happening. And I can't speak for all parents, but I'm a parent myself and an attorney. People don't want to just file lawsuits over this stuff. And I think that most families would prefer to deal with it in a way outside of the courts. This is for those very, very serious circumstances where relief cannot be had through the means that you've discussed. And yeah, like I said, I know there's a mom sitting next to me. People aren't wanting to take their districts to court. Wyoming school districts do a good job, and we're not seeing this everywhere every day. You know, this is a very rare and very serious thing, and this bill is intended to provide relief in those rare, serious circumstances.
Thank you. And just one last question. Mr. Chairman, on line 7 on page 4, we had the conversation earlier that was brought up in testimony about cost prevailing to the parent. Why not have party? Have it where whoever wins gets their attorney fees paid for. Why have it just one-sided?
Ms. Rubino.
Mr. Chairman, Senator Crum, that's a good question. And I think I'll go back to the drum I keep beating, which is this is a fundamental right guaranteed by Wyoming statute. Shifting the fees in that way, parents aren't going to be taking these cases lightly. And the school districts have, as was mentioned earlier, not unlimited funds, but more funds than a parent might have to deal with these cases. And so the whole point of this bill is to make the fundamental right to raise your kids meaningfully enforceable.
Follow up, Mr. Chairman.
Please.
Yeah, and just lastly, like I say, I'm sympathetic to this whole thing, but you know, if the school, we're talking school district here, if the school districts, if the court finds in favor of the school district, as a taxpayer, I think I would want my money paid back to the school district for the time they spent defending a lawsuit that they won, that they should get their money back. As a taxpayer, I would think that. Am I off track here or not, Ms. Rubino?
Mr. Beal.
Mr. Chairman, Senator Crum, respectfully, the parent is already paying the school district side of the defense as we have it. They're already paying for it through their property taxes. So I don't think that it needs to be a full fee shifting. I think the fee shifting in favor of the prevailing parent alone suffices.
All right. Good job, committee. I think I'm gonna have to close public comment. If you have something I can just really brief, that'd be great.
Chairman, members of the committee, I've already introduced myself, Kari Cochran. I wasn't planning on speaking, but as I heard some of your questions, serving on the school board and also reaching out to many of the entities who spoke today, trying to help problem solve through some of the district problems, I think part of it comes down to is no recourse over the school board. So when you're not having any like feedback and nobody's coming back to you as a parent and you go superintendent, you go school board, you go state, and then you go to the state school board, there is nothing else for the parent to do besides litigation. I have hired an attorney. My point was never to sue the district, but it was to have better protection for my kid and for all kids within the district. And when we don't have a remedy to remove school boards when they're not acting in the best interest, or to remove a leader who isn't doing their best job as the superintendent in a school district, which we all want leaders who lead, from not the top down. We want them to lead from the bottom up, and we want them to lift up all of the different levels of the people that fit in the school district. And when that's not happening, I think this is when this comes to play.
All right, thank you. Representative McCann, you should have punted to Miss Rubino as your counsel. She did an excellent job as local counsel, probably better than anyone from out of state would have done for you. So keep that in mind next time. All right, I will close public comment. And committee, what is your pleasure?
Mr. Chairman, I'm gonna move the bill.
Okay, House Bill 157 moved by Senator Hicks. Seconded by Senator Kolb. Amendments. We have amendments. Senator Hicks.
Oh, man, where do we start? So basically, Mr. Chairman, I think we delete everything except for go to page 3 and you bring in 14.2.206 and you bring in all of that new language that's in there. And that would be my amendment. So you're going to page basically.
Page 2 lines.
Well, you have to start at page 1.
Oh, what's on page?
Because this is creating a new body of law and we're just going in and amending an existing. So we're still going to have to include part of section 2, but I think you would go in there and eliminate all of page 1, line 9 through 14. All of page 2, line 6 through 21. All of page 3, line 1 through 16. The remainder would be the bill.
All right, let's take that First Amendment. Is there a second? Seconded by Senator Kolb. We kind of had the discussion on this, so I think we all know what we're doing. All those in favor signify by saying aye.
Aye.
Any opposed? Okay, that amendment has been adopted.
Chairman.
Yes, Senator Crum.
Yeah, I'd make a motion that on page 4, line 7, we replace parent with party. I just think that, it should be a two-way street here on this thing. And I do believe that we as taxpayers, if we're not directly involved in the suit, that we ought to be reimbursed if it's found the other way. So I would move that it be party instead of parent.
Okay, it's been moved and by Senator Crum and seconded by Senator Craigo. Any other discussion? All those in favor signify by saying aye.
Aye.
Any opposed?
No.
All right, that amendment has been adopted. There's one more amendment at least on page 4 to be consistent with the First Amendment. Senator Craigo.
Thank you, Mr. Chairman. So just belt and suspenders kind of work here, I guess. Line 4, beginning with the word "an" action, or words, I should say, delete the rest of that line. rest of line 4, and then line 5 would be deleted through 139, 113.
Second.
Okay, it's been moved and seconded by Senator Hicks. This is pretty much necessary based on what we did in the First Amendment, I think. So all those in favor signify by saying aye.
Aye.
Any opposed? Okay, that amendment has been adopted. Are there any other amendments to this bill? All right. Pierre, will you do a roll call vote on House Bill 157?
This is a roll call vote on House Bill 157 as amended. Senator Craigo.
Aye.
Senator Crum.
Aye.
Senator Hicks.
Aye.
Senator Kolb.
Aye.
Chairman Olson.
Aye.
5 ayes.
All right, very good. We'll manage the amendment. I don't know, Senator Pearson, are you here because you're managing the bill, or have you worked that out yet? Representative McCann, on who you want to manage your bill? Okay, well, you got a couple of co-sponsors, so you'll figure it out. All right, thank you. Last bill for our consideration is House Bill 92. Sexual predators prohibited from public office. Representative Lucas, we go back at 2:15 and we're going back into third reading. So we really can't miss anything. So give us the shortest version you can. And raise your hand if you came to testify on this bill. All right. Yeah, sounds good. Go ahead, Senator Lucas, or Representative Lucas.
Thank you, Mr. Chairman and members of the committee. I will be fast. This is a short bill, barely 3 pages. So I'm bringing you sexual predators prohibited from public office. This bill came about because of something that happened in real life right here in Laramie County. In 2024, a man who had been convicted twice of felony sexual abuse of a minor registered to run for Board of Trustees for our community college. He had had his rights, voting rights, restored after his prison sentences were fulfilled. And this was just fine until the public became aware of it. And then public outcry was very strong. And eventually the man withdrew his candidacy. But the question comes up that this is really larger than just one individual. As elected officials, we frequently are in positions where, first off, we're around children. Secondly, we make decisions about children frequently. And I think that being an elected official brings a position of trust that we really must consider that some folks just aren't going to be suitable for this. This bill restricts the following positions from being registered as sexual offenders: trustee of a school district, community college district board member or trustee member, county attorney or district attorney, county commissioner, member of the governing body of a city or town, mayor, county sheriff. It does not include legislators or our high positions in elected office within the state, because those would require a change to our constitution. And so we're not there yet, but I wanted to get this in.
Representative Lucas, what about the other elected county positions like assessor, clerk, coroner? Why just include the sheriff and your county commissioners?
Mr. Chairman, that's a great question. I did not, because those positions don't really seem to deal with the public as much. I wanted it to be relevant. Certainly that might be a good amendment to entertain.
Okay.
Holding public office is not merely about casting votes. It carries with it authority, access, influence. This signals trust. Appetite is high in the community for this type of restriction. People were very, very upset in 2024, and I think you remember that, sir, that we could even entertain that type of situation to occur. The bill itself is pretty straightforward. I think I went through most of the high spots there during my little narrative. I would answer any questions that you have.
Senator Craigo.
Thank you, Mr. Chairman. I know we're crunched for time. And so I'm probably under some mistaken belief that, if you're a felon you can't hold these offices as it is. You have to be a qualified elector to run for these offices. To be a qualified elector, you cannot be a felon. So I'm just curious. I must be mistaken. So hopefully someone can help me figure that out, because I know none of us could be up here if we were felons. And so unless certain things have happened following that, I don't know if that's what happened in this circumstance or whatnot, but maybe you could fill me in what I'm missing here. I could use some help.
Representative Lucas.
Mr. Chairman, Senator Crago, I'm not probably as knowledgeable about this as you are, but I did work with attorneys on this bill. My understanding is that you must be able to vote. And this
Right, that's
person
the
had
qualified
his,
elector
yes,
provision, but I think a qualified elector by statute is a bona fide resident of Wyoming who is not a felon and is of the age of 18 or older. I think that's what it requires. Unless your rights have been restored. Yeah, that's true.
and Mr. Chairman, yeah, and the age might vary depending on the position.
That's
Because-
true. It does vary.
Yeah,
Yeah.
you couldn't be governor unless you're 35. But we're not talking about the governor here. That is a really good point. I am not absolutely sure on that, but I have somebody coming up behind me who is, and he didn't write this bill. So I can tell you, I wrote this bill.
Thank you for writing your own bill.
Yes, sir. I'm
Appreciate
learning the
that.
hard way on some of this. But it is also, I know that even sex offenders who are required to register on the registry list, very few political subdivisions run background checks.
Mm.
You know, and the community college did not. And so this is one way of determining that we do have somebody who, you know, probably shouldn't be around children.
Senator Kolb, did you have a question? Or you go ahead.
I did. Thank you, Mr. Chairman. I think there's certainly some confusion in my county, because in the past, it was stated that you could run for office being a felon, but you couldn't actually be sworn into office. That's what I understood to be. That might just be the past county clerk's position. I'm really unsure, but I just wondered if you had any light you could shed on that particular set of circumstances. Thank you, Mr. Chairman.
Representative Lucas.
Mr. Chairman, thank you. Senator Kolb. I can't speak to that exactly, but the language in the bill does not pertain to running, but being elected. And so the Secretary of State or the governing body would not allow that person to assume office.
Senator Kolb.
Yeah, just quickly. Thank you, Mr. Chairman. Yeah, that's part of the problem, isn't it? I mean, you'll have somebody who gets in an elective race, and then the outcome is actually affected by that said person who can't actually hold the office. I never kind of thought that was right, but thank you, I think, for your opinion about what the clarity.
Thank you.
All right, let's take some comment. Mr. Secretary. I can't believe I'm going to ask the Secretary of State to be brief, and he'll actually be brief.
No problem. I will be brief. Mr. Chairman, thank you. I'm in full support of this bill. There have been some issues on this issue. I think it's really important to ban sex offenders from running or holding these offices. I would welcome those amendments to expand into the other county offices on the ban, and I'm in full support of this bill.
That was brief. Thank you, Mr. Secretary. Any questions? Yes, Senator Crago.
Mr. Secretary, thank you for being here. My question about felons already being prohibited, do you have any insight on that?
Secretary?
Yeah, Mr. Chairman, wanted to be brief there, but yes, I'm happy to address that question. There's two possibilities. One is this run versus hold distinction. That has been the case in some of these cases. This statute just nips it in the bud in saying that you can't do either. So you've had these cases where you've had somebody run and in terms of holding, if they were to win, there would have been issues there. But then also you have the restorations that have been done. And in some cases, these situations, there have been situations where people have been catched into those restorations, at least for holding office, that maybe we want some clarity from the legislature on. And this is one of them, that I think clarifying that the restoration of holding office would not would not apply to sex offenders and running for office would not apply to sex offenders. I think that's appropriate policy choice. So there's two possibilities depending on the situation where there have been some issues there. And I think this law handles both.
All right, thank you. Other public testimony, just come up and fill up the chairs if you're gonna testify. We've got two minutes, so give me your minute testimony.
Chairman Olson, I think I'll stand in for the other individuals just to make this quick and answer Senator Crago's astute question.
Yes.
In a short period of time, there's a loophole in Wyoming law. Essentially, a felon who would not otherwise be a qualified elector may, through certain administrative processes, have their rights restored. However, that is only for nonviolent felonies. Through the administrative process. Unfortunately, Wyoming law defines nonviolent felonies in a very strange way that would render certain felonies such as the sexual abuse of the minor in a first, second, or third degree as nonviolent. I have some really just heart-wrenching examples I could provide here. For the sake of time, I won't. So in my mind, this legislation is designed to fill a loophole where I don't think the legislature intended for a 35-year-old having sex with a 13-year-old to be, quote, nonviolent. This is the loophole that fills. I also must note that it's important in this case because the primary difference between first and second degree sexual abuse of minor, which again is that nonviolent loophole, is positions of authority. Simply put, we're trying to prevent individuals with a past that may not be statutorily violent, in quotes, but whose the nature of whose crimes should never allow them in position of authority over children. If we had time, I believe my counterpart here would be talking about recidivism rates and how the numbers just don't stack up. But we would respectfully submit to this body that this is a loophole that must be filled to protect our children from those who have criminal past.
Senator Culp, go ahead.
Yeah, thank you, Mr. Chairman. Just a matter of the mechanism of how this would work. Does the clerks have the authority to do a FBI background check or whatever necessary background checks you have to make sure that person doesn't have such a background? I mean, how would that actually work? I just need to know, like, do they have the authority to do it? Is that I've heard there's an issue with them doing certain things in background checks, and I just wondered what your opinion was on that.
Astute question. Thank you, sir, Mr. Chairman, Senator Kolb. I don't know the direct answer to that, but as the practical answer is, as we know in the cases that brought this here today, rather simple. This only works for individuals who are, as amended today, I should say, who are currently on the sex offender list. That's public knowledge to anyone, and it should be easy enough to find. There is a chance that this is an imperfect solution, but it will fix the known issues. And I believe it would be appropriate to let it advance at this stage.
And can you email us those statistics that'd be helpful. Okay. All right. You good? All right, thank you. Any other public comment? I will close public comment committee. What is your pleasure on House Bill 92?
Move the bill.
Moved by Senator Kolb,
Second.
seconded by Senator Hicks. I mean, I personally think we should include all of the countywide elected positions. I think they're all positions of trust that are held, I think, to be consistent. That's my thought.
I'll offer an amendment to that effect.
Okay, Senator Hicks.
So it's broader than that, Mr. Chairman, so.
Okay, let's hear it.
So we, under trustees of school districts, we'd also include the state school board. Under Romanet 2, community college district board members, University of Wyoming Board of Trustees would be the other addition. We get down to county and district attorneys, include city attorneys. And then when you get down to county sheriff, we'd add treasurer and clerk on that list also. I'm sure I'm missing at least a number of appointed.
You got well, on the bottom one, you've got coroner, treasurer, clerk, district court clerk.
I didn't include the coroner. That would be the other addition, Mr. Chairman.
Okay.
Mr. Chairman, a friendly amendment to that would be city council members too.
They're on here, member of a governing body of a city.
Okay.
Or town.
Okay.
So whatever they're called, they fall into that.
Okay.
Senator Crago.
Mr. Chairman, well, I'll wait till that amendment, till you've dealt with that amendment. Sorry.
Okay, is there a second on the amendment?
Second.
It's been seconded. Any other discussion on the amendment? Pierre, you got it? Okay, all those in favor signify by saying aye.
Aye.
Any opposed? All right. Senator Craig.
Mr. Chairman, I think we should include all of our state elected positions as well. The legislature, the governor on down. I mean, we're gonna look ridiculous when we get to the floor and we've exempted ourselves out. I make that motion.
Second.
Second.
Okay, it's been moved and seconded. So there will have to be some language in here about a constitutional amendment or no?
Mr. Chairman, I don't think so. I think this is already, I think this bill, number one, I don't think it's necessary because I think these folks are covered by our current law. So we can't serve as felons anyways. And so that's really what we can't. That's in existing law. Now, there might be a loophole for whether you're on the sex registry or not. If you were able to get your voting rights back at some point, it's because you qualified under one of these others. And remember, we're talking about, for example, someone who's 18 and possibly had sexual relation with their girlfriend, or 19, or what. I mean, when we start getting into those very discrete third degrees, where 20 years from now, we're telling someone they can never serve in an elective office and they ended up marrying. I mean, we've heard this story. For those of us that have been on this committee long enough, we understand there's nuances to this. You will end up on the registry, but you might be married to the same person you were convicted for having a relationship with. And I'm not sure I want to go that far anyway. So this is something we got to talk about, I think. But I guess I'm not sure why we can't include ourselves on the list. I don't know how it even invokes the Constitution anyways, but we can deal with it later, but I'm at least going to make the motion.
Okay, the motion is to include all statewide elected officials and the legislature.
Second.
It's been moved and seconded. Any other discussion on this amendment? All those in favor signify by saying aye.
Aye.
Any opposed? Okay, that amendment has been adopted. Is there anybody else we can add to the list? We're just gonna make sure it's covering everyone. All right. Okay, Pierre, do you got those amendments? Will you please do a roll call vote on House Bill 92?
This is a roll call vote on House Bill 92. Senator Crago.
Aye.
Senator Crum.
Aye.
Senator Hicks. Senator Kolb.
Aye.
Chairman Olson.
Aye.
5 ayes.
All right, Representative Lucas, there you go.
Everybody.
Thank you for your brief testimony. I'm sorry I had to rush everyone, but at least we got it through.